Welcome back to Between Two FARS. I'm Monique Miller, here once again with the legendary Robert Tepfer, continuing our discussion about debriefings and how you can, let's give our audience some practical tips about what you can do in the debriefing to lower your litigation risk. Or maybe, in the converse, some ways you can screw up and increase your litigation risk.
All right.
Let's parade the horribles, Bob.
Okay, yeah, that's what I'm good at. Okay, first off, one voice. Okay, you may have to break it into different sections, but to keep control, you have one voice, and everybody needs to be aware that that individual is going to speak in that area.
Okay, and what you mean is the contracting officer would probably open the debriefing and sort of be the ringmaster of the debriefing circus, and if somebody else on our side is going to talk, they're the ones who direct you to do it. Is that
Yes,
the
that's right.
one voice that you're talking about?
Yeah, you know, they have specific areas. You might have pricing, you might have the past performance, you know, in the technical area. You don't want to have confusion over who speaks and in what areas, because if that happens, people won't be prepared. They may put out opinions that aren't part of the consensus, aren't reflected in the findings or the source selection statement, and then subsequently they'd be the ideal witness to have at a mini trial or full-blown hearing.
In front of the GAO.
Yeah.
That's how you're talking about making yourself a star.
Oh,
in our last
absolutely.
episode, yeah.
You'll
So
be a star.
you don't want to be a
right?
star.
No, you don't want to be. Another thing, overarching, that folks need to consider is the fact that there's a lot of therapy that needs to take place.
Yes.
A lot of us in the government, myself included, have worked for the government for many years, and there's a lot of stability in that area that isn't present with some of these companies. If they've had a contract and they lose it, you know, you've got folks that have to go home and explain to their spouse that life may not continue the same way, that they may have to move, the kids can't go to the school they wanted to, and that's a very, very emotional topic.
Yeah.
You know, it may just be another day in our lives to explain in the debriefing, but for these folks it's very significant and it can have a tremendous impact on them. And that's very, very sad. It's a bad thing to have it get out of hand and have those emotions take control. So you got to control it instead.
I always kind of say, allow them to vent their spleen. You remain the adult in the room and allow them to, you're the face of the government for them in that moment. You are the only people that they get to interface with, who've done them wrong, who've done wrong to their company, who've hurt their families, and you've got to be able to take that. And sometimes if you do it properly and they feel that they've had some emotional closure, some of these small businesses or ones that don't have an attorney yet, that may be the end of it. They may not take it to the GAO.
Right. Now issues of past performance are a particularly emotional subject.
Yes.
Because you're talking about, you know, how they've performed, and it may be a sore issue from the past and you're ripping off the scab, and so you got to be very careful in that area when you speak to that. Yet it'll have to be included in the debriefing, so be aware. There are other issues, and effectively what you try to do is, once you've gone over a lot of the materials and you sense that a debate is going to take place, where why isn't this a significant strength? Why did you find that a weakness? I encourage folks to have on the slides the process of the debriefing and the fact that you're right out of the FAR.
Yes.
I try to prevent an attitude of developing of, I'm not going to tell you. I'd rather have it be an issue of, I'm not permitted to go into. That's one of, as I tell the folks that I'm briefing, there's power in being powerless. You can control it, and it's not you versus them. It's the process that we all signed up to. And the best way to do that is with slides.
Yes. Sometimes we have on the slides, we will not discuss hypotheticals. And that has been such a powerful one to go back to, because that's not talking about our process. That's not talking about how we applied our required process to their proposal. When they say, well, what if we, and you just point to the slide, as we said on slide 3, we will not be discussing hypotheticals.
And the other one that they want to get into quite frequently is why did such and such company get credit for this or that, or evaluated accordingly? It's it's a hyper issue from the standpoint that they may be competing against this company routinely, but what you have to tell them is, look, you wouldn't want us to go into your proposal, your proprietary information with them, and we can't do that in this meeting as well, because it would expose them. And we protect. It's an issue of public trust. It's our opportunity to be on stage to demonstrate to them that we do take those issues seriously. And they need to understand that. One of the things in one of the slides, like I said, you take those right out of the FAR and put it up there, is they come on and they'll say, it says right there that I'm entitled to reasonable responses to questions. And you have to read the rest of the paragraph, which says to matters of process, application of regulations, and the statutes. And you explain to them that it is a process briefing, and as a result, you are not going to answer questions regarding the evaluation itself, because you don't have the consensus there. And you always get a little bit holier than thou and say, I would never speculate as to the thoughts of the source selection authority and how they concluded in a value analysis based on the criteria this way.
Now, at the same time, it's important to listen to them, not only for that emotional moment they may need to have, but also there have been a couple of debriefings I've been in where they've pulled something to our attention that might be a problem for us, and we did need to think about and maybe contact our technical people before we give them an answer, before we give them a response. How do you suggest we handle that sort of situation in the moment?
Well, what I try to do, and it's always going to be fact specific, is you remember I said you don't have the whole board there, because you don't want to have a consensus issue again on a finding or something like that, notwithstanding the fact that they can't ask about hypotheticals, they can't speak to the detail, but I like to have them available by cell phone. I always tell them I don't know what the issue would be, but if we need to, we might have to caucus, and I've had that happen a couple times.
Now, explain what a caucus is. That's not something done in front of the offer,
no,
is it?
It most definitely isn't. It's, that's an interesting issue, you might state. Let me contact members of the board and see whatever it might be. And you call them up and said, what exactly happened, or what is this, that kind of thing. Again, it better be in the context of process. It needs to be in an area that you are committed to discuss. But if that were to occur, and I'm always reluctant to speculate what it might be, that's how I would approach the issue. The key that goes along with that is it's imperative that you say at the end that this does in fact conclude the debriefing, because the last thing on earth you want is an email back and forth or a dialogue in any fashion which shows that you're not done, because your 10 days to the protest won't be showing up until it's concluded. So the last slide ought to say this concludes the debriefing.
And in the very oddball situation where you're not able to work through the issue, the valid issue the offer has raised during the debriefing, there have been times where I've said, we will give you an email response within 24 hours, and then the email that goes out with that response says, and this concludes the debriefing to start your clock. Now that, we don't like to get into that as a practice,
I certainly,
but there have been one or two times where we've had to do that, because sometimes the offerers bring up issues that we really do need to run to ground.
Yeah, and I guess that makes me nervous, but I can see where it could occur.
Okay.
And along those same lines, one of the things that's very sensitive to me is giving them the source selection statement early and having them show up with a bunch of prepared questions. You can end up with a problem right at the beginning saying, I'm not going to answer that. This is a process briefing, but you may have to have that. And, it may get to the point that it has to be information obtained under a protective order, and it may end up, obviously, if you got a protective order, you got to have counsel.
Let's talk a little bit more about the nuts and bolts about how to do that in our next episode.
Okay.
Join us back here between two FARS.